So there are differences between adults and children, but what you can see is that these legal frameworks, this rule of law, is explicitly, and I mean explicit, recognition of both violence, like personal violence, of the violence that marginalised groups are subject to. So within children's legislation, it is explicitly recognised that child sex abuse exists, that physical abuse exists, that emotional abuse exists, and that women have a responsibility to protect their children, which we act on. So this law has not ceased to apply to women. And then with adults, you see how the law is recognition of the marginalisation that would leave them subject to state abuse. And the crossover between vulnerable adults and children is incredibly important, because once a vulnerable adult is the carer for a child, they are basically no longer considered in that equation. The child is. So we know all this already. This is very, very, very well established. You know, the reason that people think intersectionality is about feminism, because in the US, where intersectionality, where she was discussing the way that women have organised, it's not the rule of law. Here it's not feminism. This is long established law. Now, I want to talk finally in this video about equality legislation and where it fits, because equality legislation is largely a symbolic recognition that equality is contested, an agreement that the state recognises it. It's largely toothless. It's very rarely used. It can't be used mostly. It's it creates legal fictions. Actually, what Crenshaw was describing was the way discrimination legislation on its own creates legal fictions, which create blind spots where women are harmed. In English law, as a consequence of common law and precedent, and as a consequence of laws and challenges by other people, and all of these laws have come into being through a process of social change, tragedy, state failure, and that's where these lessons are. They exist, and equality legislation is supposed to be recognition that equality is contested for groups covered by that. And then, if we look at the relationship of these laws to our cash transfer system, we find where the problem is. So our cash transfer system our cash transfer data should, and absolutely does show, and you don't even need to look at the data, you just need to look at the names. It corresponds exactly to equality legislation. It's a dynamic, accurate reflection of inequality. And it's also the income for all those people. So all those people where the state has recognised that their lives are a combination of a risk of state abuse and or violence, where those rights and recognition have built up over 70 years, our cash transfer system is the income for those people. And welfare spending corresponds directly to equality legislation. And we already know all this. And what was decided in 2010 with austerity was that the focus of austerity would be on our cash transfer system, on these systems, and on these people. So most of these people are not people for whom employment is even a factor. Most of these people are people where we're talking about inequality so severe that inequality is not an option. So what austerity essentially did was it rolled back protection from violence and state abuse for the most vulnerable people in the country. And this was by consent. Now, I know I've met the economists at the LSE, they just can't see these systems, they didn't know they existed. It doesn't make it okay. It doesn't make it okay that our 3 universities couldn't see these systems. But what Twitter has given us is an example of what happens if they mix a social dimension to communication with us during the period where that was attempted. And we have seen the violence and abuse. And largely what, you know, the very marked difference between, the only difference between Owen Jones, Ellie Mae O'Hagan, the norovirus brats, and the media class that they come from, is that when they were faced with the rule of law around violence and abuse, and protection from state abuse being removed from, you know, every single right in the 20th century being removed from the absolute most vulnerable people, and when they were told absolutely and explicitly that the consequence here was violence, because it is violence for these people, they used intimidation and abuse, because they showed that actually they did recognise that marginalisation means intimidation and abuse. And they did that by abusing welfare claimants and social care users and single parents to prevent them discussing that. But now we're at the point in time where, much like TERF, the dissonance is falling away, because it will, because we have institutional failure, we have institutional breakdown happening. We have to redefine these systems, and the political crisis that are being generated, which will now expose this rule of law and are exposing this rule of law, much like the TERF crisis has just been, you know, trans activists demanding a safeguarding debate that they couldn't have, and then demonstrating male pattern abuse and the nature of the structure of these laws. That's going to continue. I don't know what to tell you. And the rule of law that's kind of outlined in this playlist is what will be exposed by that. So that's why I've done this crisis. I've done this playlist. But what I'm going to do with the next video and the final video is I'm going to look at 2 or 3 specific case studies of actual people that were caught up in this, to give you, you know, an overview of what that looks like.